Good morning, good afternoon, good evening, wherever you are, whenever you are watching this video. Appreciate you tuning in today. Thought I would make a relatively short video today. Went to a concert last night with some friends. It was good to catch up with them. And I was struck at how few people were at the show. My suspicion would be that money is tight for a lot of people right now, particularly the younger audiences that are fans of this particular group that I went to see, but that's just speculation. But I've mentioned, obviously, in videos and in my handle on YouTube that I'm an attorney. First of all, let me say that never am I going to give legal advice on a video. I might reference some best practices or things that I'm seeing in my practice. I do primarily workers' compensation law, so I represent people that have been hurt on the job. I represent people who have been sexually harassed at work, or people who've been discriminated against on the basis of race, sex, sexual orientation, gender, religion, national origin, or age, and similar claims under what's called Section 1981 as well, which is similar to some of those Title VII areas of law. But you can Google it if you want to look at what type of discrimination does Title VII prevent with regard to private and government employers. What kind of things does Section 1981 protect against? But so I represent workers who believe that they have been treated unfairly in a legally significant way with regard to federal employment law. ADA, Americans with Disabilities Act. So if you've been, repositioned, or had your pay cut, or been demoted, or been fired, allegedly as a result of a serious medical condition that results in restrictions that your employer would need to know about and need to engage in a dialogue with you about, then you might have a claim. But really the key for those, so workers' comp is just, did you have an accident at work, right? And if you did, then there's certain benefits that you get under law. Employment discrimination is a little more complicated, but it's a whole host of federal statutes that protect against employers doing certain things to you. We call it an adverse employment action. So basically, the state that I'm in, they say it's an at-will employment state, right? So they say, the employer can fire you at any time for any reason. And that is largely true, but they can't fire you on the basis of certain protected characteristics. So basically, I represent people in the employment law context who have had an adverse employment action like termination, demotion, reassignment, some kind of meaningful change in their employment, allegedly on the basis of some federally protected characteristic. So while it is generally true, employers can, at least in states like mine, change characteristics of your employment or fire you for any reason, unless you have a contract of employment that prohibits that. But most people don't. The vast majority of people don't have a contract. Employers can't engage in adverse employment actions on the basis of a protected characteristic. So basically, I'm representing individual employees against large employers, large corporations, and occasionally the government. And we also do general injury cases as well, negligence and slip and falls, premises liability. I feel like right now, and it's on my mind going to the concert last night and seeing how few people were there, and just sort of a lot of people I know having financial insecurity right now, a lot of people I know having job insecurity right now, and also just the general state of the world where it seems like people are just not doing well. I think that it's good to take a deep breath and kind of just assess where you are in your career, or if you're getting near retirement. I think this is just a really great time to look at and assess sort of my relationships to other individuals or entities, because we're in a changing world. Ray Dalio has written a book about it, about the changing world order and about the debt situation here in the United States. And so we're in a weakening economy, number one. We're in an increasingly AI, artificial intelligence, impacted economy. So employers are going to be looking for ways to export tasks and jobs that were previously done by employees to artificial intelligence agents, and that is happening. And I would think from what I've heard that that's going to start happening at an increasing pace. Having a little lemonade today. And as we slip into recession or worse, Ray Dalio has indicated he has concerns about something worse than a recession. As we slip into a recession or tougher economic times or more political instability, people are going to be raising up their guards, right? Like the Starship Enterprise raising their shields against the Klingons. You got to think of it like individuals and also businesses. They're going to be thinking about how can we become more, how can we widen up our stance, put the shields up, and become more defensive. So it's going to become less about how do we go out and make lots of money. It's going to become more about how do we protect the money that we do have and that we are making, and how can we save on the expenses that we have and need. And so obviously AI is probably the biggest single factor in the cost savings aspect of it. And then the AI is going to enable employers and businesses to cut time for workers and lay workers off. So I would never tell someone to look for a legal case, right? You don't want to go looking for a legal case, but it's just good to be aware of what's going on in the broader world, because when employers get defensive, there's a greater chance that they're going to be looking for reasons to cut the workforce. Also, when people are stressed out and there's political instability, safety oftentimes will be compromised, corners will be cut, and people will get hurt. So, so you have really both workers' comp is impacted and employment cases are impacted. And another thing is, in a good economy, strong economy, growing economy, if you have a really good job and you feel really secure in that job, you might be willing to look away from things, right? If someone is treating you wrongly, but you're getting paid well, and you feel like you're going to be able to have job stability there and get a vested 401k and retire at some point, you might be willing to look away from behavior that might otherwise be intolerable, for example, in the type of economy that we are moving toward now, I believe. So the big thing is, if you see something with your job, you need to say something. The biggest challenge that I see to people having cases against their employers for adverse employment actions, or say if they're hurt on the job, or they need accommodations, or they need medical treatment as a result of something that has happened on the job, or they need medical treatment for something that did not happen on the job, but they need accommodations in the job for the job to work with them. The biggest thing is a lack of evidence, right? You don't want to have a legal case and it's just simply he said, she said, because HR departments exist to help the employer. Let me say that again. Human resources departments exist to help the employer. When an HR department, in my opinion, in my experience, when an HR department gets involved in an investigation, that investigation may not be for the purposes that you, being an honest, upright person, would think that HR investigation would be for. You have to protect your evidence. You have to obtain your evidence. Just because everyone at the job or everyone in HR knows what really happened, you cannot count on that. And so you need to have receipts. You need to be able to show that. You need to, when you go to get a legal consultation with a lawyer who practices employment law in your jurisdiction, your state, or the District of Columbia, like you need to have the evidence. You don't want to be in a situation where you're telling your lawyer, well, HR knows all about that because they did an investigation. Because what you think Human Resources has, or what you know they have, you sure they're going to be honest? So, document. If you have a work injury, number one, you need to report the work injury immediately. Report the work injury immediately, and make sure that you do it in writing or in such a way that you on your own, without having to take anything that doesn't belong to you with regard to the employer, that you have written proof of exactly what happened, when it happened, how it happened, if it involved another human being, what they did wrong, or if it involved a piece of equipment that you believe you weren't trained properly on, or a piece of equipment that malfunctioned. You need to have all those details, and you need to report it, right? Now, the general rule is, if you get hurt at work, you can only sue your employer in workers' comp. And whether you consider a lawsuit or not is kind of just a semantic thing. It's an insurance claim. Workers' comp is an insurance claim. In most states, it functions very similar to the court system, but it is typically an administrative body that just kind of oversees those insurance claims, and typically the administrative body that oversees the workers' comp claims borrows from regular court, judicial court, for the processes and the procedures. Usually it borrows very heavily from that, like the exchange of information. In my state, the exchange of information in a workers' comp setting is the same as it is in just regular, civil court, divorce court, or alimony court, or contract court. But it's administrative law, and at the end of the day, it's a little bit more within the purview of the administrative body, what to do, how to handle the case. So the bottom line is report, record, receipts. Report, record, receipts. And that's and I'm not saying record conversations. Depending on what state you're in, you might be within your legal rights to record a conversation and the other person not know about it. That varies from state to state, so you have to check your own state's laws about that. In my state, I can record a conversation I'm having with someone else as long as I'm consenting to the recording. So I can't go eavesdrop on two people, but if I'm a participant to the conversation, I can record it. From an audio standpoint, video is something different, but every state is different. But report, record, receipts is a good moniker for any kind of what could be a potential claim. And really what I'm getting at here is many of you, if many of you watch this video, right, which who knows, I don't really control that, but whether you have a potential employment claim or a potential workers' comp claim, you want to report, keep records, and keep receipts for what happened, how it happened, who, what, when, where, how, and why. Now, why is a subjective. That's going to be in the eye of the beholder, but obviously you are going to have your position, your opinion as to why something happened. So your report and your recording and your receipts should be able to show a third party what happened, when it happened, where it happened, how it happened, who was involved in it happening, and then your belief as to why it happened, right? For example, in an employment discrimination case, why it happened is what the court is going to have to decide. You're going to say that you believe it was because of race or sexual orientation or gender or age or whatever you believe, and then the employer is absolutely 100% going to say no. Like, employers do not agree that they have discriminated against anyone. So that whereas an employer might agree that you've been hurt on the job, an employer is never going to agree that they discriminated against you on the basis of some protected characteristic, right? That's what we call age, race, disability, gender, national origin. Those are protected characteristics. They're protected because the law protects you from having an adverse employment action taken against you by your employer on the basis of any of those characteristics. So you can just Google what are protected characteristics under federal employment law if you want to look at that yourself. You can Google what are the sources of law that make that be the case, right? You can learn all about that. The law is federal, but bizarrely enough, the law is a little different in, for example, North Carolina than it is in California. It's a little bit different in New York than it is in Colorado, and that's because the district courts, the federal district courts in the various districts of the various states interpret the laws differently. And so, unless the Supreme Court has decided a specific issue, you might have the district courts in North Carolina saying one thing about an issue, you might have the district courts in California saying something different, right? California is probably going to lean more toward being favorable to the employee. Other states, you can probably figure out which ones those are. Other states are going to lean more heavily in the favor of the employer. The state that I'm in is pretty hostile to employees. They really, really want to protect their employers, particularly the big ones. And so, you really have got to come with the heat. If you gotta have the evidence, because if you don't have the evidence, you won't get to a jury, because they'll kick you out. The judge will kick you out. So, to sum up this video, it ended up being a little longer than I was expecting. Why am I talking to you today? The economy is weakening. I believe it's going to get a lot weaker. Employers are going to be looking to save money and put AI in there for your job if they can. And so it might be time for you to open your eyes if you've been overlooking sexual discrimination, sexual harassment, race discrimination, age discrimination, disability discrimination. If you have been grinning and bearing that back injury that your work is making worse every day, and you're not filing a claim, you're not pursuing your legal rights because you're trying to, save that job, I'm simply saying that the calculus may begin to change. I'm not suggesting that you go and file a lawsuit against your employer. I'm saying that you just look at the big picture. Look at the big picture, because people are going to be getting laid off. People are going to have their pay cut. People are going to get reassigned to jobs they don't want in an effort to push them out. People are going to get fired. People are going to get demoted. That's what's coming. And so, if you do have a legal claim, you do not want to sit on it. All I'm saying is, if you absolutely know that under no circumstances would you ever sue your employer, ever, doesn't matter what they do to you, then you don't need to be watching my video, right? But if you got something going on, and you know it's going on, and you've been overlooking it because you're expecting, to keep working there, well, are you? Are you going to be working there? Are you going to still be working there in 6 months? So I'm not saying to cook up a case you don't have. I'm saying to protect the case that you do have, that you've been not protecting because you never intended to sue your employer. So report what happened, whether it's a disability, discrimination, age, sexual harassment, or if it's a workplace injury. Report it. Make a record of the report. Get a copy of the report. Your job may have a specific process that you have to follow. The reason I'm not telling you what to do in terms of how to give the report is different employers are going to have different processes, and you need to go by the handbook. Whatever I know they probably aren't going by the handbook. I know you're going to say, but hey, my employer doesn't, that handbook is emergency toilet paper to them. It may be. But you need to abstain from the appearance of evil. It's hard to do when other people are being evil and they ain't abstaining from nothing. But you want to abstain from the appearance of evil. And so follow the protocol, but also make sure that you, on top of that, are following whatever protocol you need to follow to record and report and keep the receipts that your employer knows your contention: who, what, when, where, how, and why. And big thing with employment cases, you have a very short period of time after an adverse employment action. So after you've been demoted, after you've been fired, you have a very short window of time in which to file a charge of discrimination with the Equal Employment Opportunity Commission, the EEOC, and you must do that. You cannot go straight to court with a federal employment case. You must file the charge of discrimination, right? It is possible to do them on your own, but of course I always recommend that you talk to a barred, experienced professional attorney licensed in your jurisdiction with an expertise in employment cases, always recommend that you talk to them, even if it's just a consult. But it is a very short window on your charge of discrimination being filed. That's where you're going to file the official event as you see it with the EEOC. Then the EEOC will go through a process of looking at that. Don't expect them to do too much. They're not going to adjudicate anything. You have to file this charge with them, and then they'll eventually give you a notice of right to sue, and then you have another very short window of time after that in which to file suit. So if you were to do your own charge of discrimination, you absolutely have to be on top of when you get your notice of right to sue, and you have to be getting a lawyer very quickly. Or if you don't recommend filing a federal employment lawsuit pro se, but if you choose to do that, it's fraught with very, very stringent short deadlines. So just make sure that you know what's up. And so that's going to be it for me today. I hope that none of you are having these types of issues. I hope that all of you guys are at complete employer-employee bliss at work. But I know that's not the reality for many people, and so I'm here for you when that is the case. And so good luck to you all, and look forward to seeing you all very soon.